Welcome to perhaps the most important episode of the Patent Bootcamp, the 4-part series that'll teach you everything you should know before getting a patent. Today will be a high-level overview of the entire patent process. First step, before you invest time and money into a patent application, a patent search can help you determine if your invention is even patentable in the first place. These searches can help you identify existing patents that might overlap with your invention. The search isn't about finding identical ideas. It's about determining whether your invention is novel and non-obvious, two key requirements for patentability. Note, however, that you're required to disclose information material to patentability. That means that if you conduct a patent search and you find a bunch of patents and publications that are really harmful to your patent application, you have to tell the patent office about it. Whereas if you hadn't conducted the search in the first place, then you wouldn't have anything that you have to disclose. So there can be advantages and disadvantages to conducting a patent search. Next, the claims are the heart of your patent. If you scroll to the very bottom of any US patent or any US non-provisional publication, you will find a listing of claims, often 20, though the number can vary. These claims define what's protected and what isn't protected by the patent. In other words, you can think of them as a fence that surrounds your intellectual property. Crafting strong claims requires precision and strategy, and it's arguably the most vital part of a patent attorney's job. If your claims are too broad, then the patent office will most likely reject your patent application. On the other hand, if your claims are too narrow, then competitors can design around your patent. There are two main types of patent applications. First, provisional patent applications essentially hold your place in line for up to a year while you wait to file a non-provisional application. You're not required to file a provisional application, but the advantage is they're generally cheaper than non-provisional applications. So you can file the provisional application to save you money in the short term, and then after 1 year, you can file the non-provisional. Remember though, if you don't file the non-provisional within a year, you lose the rights under the provisional, and in any case, the patent office is never going to actually examine a provisional application or grant a patent from one. Instead, they wait for you to file the non-provisional application. Now, the non-provisional is essentially the real patent application. This is the one that the patent office is going to examine and eventually, hopefully, is going to grant so that you can have a patent. So let's say you've finally filed a non-provisional patent application. Congratulations. The next step is for the patent office to review it. Spoiler alert, they're probably not going to grant it right away. In fact, it might be a good sign if the patent office doesn't immediately grant your patent application. Let me explain. Generally speaking, there will be a series of office actions and office action responses between the patent office and your patent attorney. In this back and forth, the patent office is essentially trying to make sure your patent is narrow enough that it is truly novel and non-obvious. On the other hand, your patent attorney is trying to make sure your claims are as broad as possible so you can have a wide scope of protection for your intellectual property. If the patent office immediately grants your patent application without any sort of back and forth, it's a little bit like walking into a used car lot, making an offer on the car, and having the salesperson immediately agree with no negotiation whatsoever. In general, you sort of want that back and forth so that you can get the broadest claims possible, while the patent agent can ensure that your invention is truly patentable. On average, it takes 26.1 months to go from filing a patent application to final disposition. Having said that, the patent office gives patentees a second option where they can pay extra to do what's called filing track one. If you do this, the average pendency reduces to about 5 months. If the patent office decides that your invention is novel, non-obvious, useful, and part of a category of patent-eligible subject matter, then congratulations. They'll issue a notice of allowance, you'll pay an issue fee, and your patent will be granted. That issue fee, by the way, is one of at least a half dozen fees you're going to have to pay to the patent office throughout this process, so watch the first half of this video if you want to go over all of the costs that go into getting a patent. Now that you officially have a patent, you get to enjoy the divine blessing that the patent office bestows upon us all called maintenance fees. I'm sorry, they're not nearly as much fun as that made them sound. After 3.5, 7.5, and 11.5 years from the date of grant, you have to pay these maintenance fees, which are essentially an additional fee to keep your patent alive. If you pay it, you keep your patent. If you don't, the patent goes abandoned. Assuming you pay all of your maintenance fees, the term of a patent is generally 20 years. What about design patents and plant patents? Great question, other me. Plant patents, like utility patents, last 20 years, and design patents last 15 years. The next step I recommend is watching the other 3 videos in the Patent Bootcamp series, linked in the description below. And if you want my help getting a patent, please go to inripatentlaw.com/contact. My name's Brad Henkelman with INRI Patent Law. I'm a licensed patent attorney with experience representing everything from Fortune 500 corporations to brand new startups. If this video is helpful to you, don't forget to subscribe and to hit the bell icon so that you're notified when we post new videos.